If you were born in another country but went through the legal process to become a United States citizen, this update is one you genuinely need to hear. Because what is unfolding in 2026 is raising serious questions that millions of naturalized Americans are asking right now. For a long time, the general understanding has been that once you complete the naturalization process and take the oath of citizenship, that status is yours permanently. But in 2026, that sense of security is being tested in ways that many people did not anticipate. The federal government is currently revisiting old citizenship files, some going back 10, 15, or even 20 years. And the scale of this effort is something immigration experts say is genuinely unprecedented in modern American history. I'm Zane, and here at Senior Security Updates, we believe every person deserves clear, honest, respectful information, especially when the topics are complex and the stakes are high. Today, we're going to walk through exactly what is happening, who may be at risk, what legal protections exist, and what practical steps you can take right now to protect yourself and your family. What is a naturalized citizen? Before we get into the current developments, let's make sure we're all starting from the same place. A naturalized citizen is someone who was born outside the United States and went through the formal legal process to become an American citizen. That process is not simple or quick. It typically requires years of legal residence, already holding a green card, passing both an English language assessment and a civics examination covering American history and government, undergoing thorough background checks, completing an in-person interview with an immigration officer, and ultimately attending a ceremony where you formally take an oath of citizenship. For most people who go through this journey, that final ceremony represents one of the most significant moments of their lives. Years of patience, hard work, and commitment, all leading to a moment of belonging. The expectation, and the legal understanding, has always been that this status is permanent. In 2026, that expectation is being examined in new ways. What is denaturalization and why is it getting attention now? Denaturalization refers to the legal process by which the government seeks to remove someone's citizenship status through the courts. This is not a new concept in American law. It has existed for many decades. Historically, however, it was applied only in the most serious and narrow circumstances, such as cases involving individuals who were found to have concealed involvement in grave crimes when they applied for citizenship. The historical numbers reflect just how rare this was. Between 1990 and 2017, an average of approximately 11 denaturalization cases were initiated per year across the entire country. Even during the first Trump administration, from 2017 to 2021, a total of roughly 102 cases were pursued over the course of all 4 years, about 25 per year. These figures establish an important baseline. Denaturalization was considered a serious, carefully deployed legal tool, not a routine enforcement mechanism. What changed in early 2026 is significant. The current administration issued new guidance directing U.S. Citizenship and Immigration Services, USCIS, the federal agency responsible for immigration and naturalization, to refer between 100 and 200 denaturalization cases per month to the Department of Justice. To put that in perspective, that represents a potential increase to as many as 2,400 cases per year, compared to the roughly 11 per year that was the historical norm for most of the past 3 decades. Immigration attorneys, policy analysts, and former government officials have described this shift as extraordinary and without modern precedent. The official justification, and why experts are raising concerns. The official position from USCIS is that this expanded effort is directed at individuals who obtained citizenship through fraud or deliberate misrepresentation during the application process. A spokesperson described it as a zero-tolerance approach to dishonesty in naturalization. On the surface, most people would find that principle reasonable. The concern raised by legal experts is not with the principle itself. It's with the practical implications of applying it through a mandatory monthly quota system. When any agency is required to produce a set number of cases every single month regardless of circumstances, there is inherent institutional pressure to meet that number. Former USCIS official Sarah Pierce, in comments to major news outlets, noted that requiring monthly quotas that are many times higher than recent annual totals risks converting a precise legal instrument into a broadly applied one, and that this creates anxiety for millions of naturalized Americans who did everything by the book. The concern, in plain terms, is this. When the pressure to produce cases is high enough, the threshold for what qualifies as a case worth pursuing may drop, potentially sweeping in people with minor paperwork errors, old administrative mistakes, or technical discrepancies on decades-old forms that would never have been considered meaningful issues under prior standards. What is actually happening on the ground? USCIS has been reassigning specialized staff to offices in various states with the specific mandate of reviewing old naturalization files, applications that were approved years or even decades ago. These reviewers are going through historical records looking for potential grounds to challenge previously granted citizenship. Consider what that means practically. Someone who became a citizen 15 or 20 years ago, who has built a home and career here, raised children, paid taxes, voted, perhaps served in the military, that person may now have a government official somewhere reviewing their old immigration file for a potential challenge. This effort is taking place within a broader set of immigration policy changes that have been implemented since the start of 2026. These include expanded enforcement operations in cities across the country, increased scrutiny of marriage-based green card applications, with greater emphasis now placed on evidence of a genuine shared life together rather than just legal marriage documentation, and changes to the naturalization examination itself. Regarding the civics exam, beginning in early 2026, the test was revised to include 20 oral questions, double the previous number, with applicants required to answer at least 12 correctly to pass. The exam structure has been updated to require applicants to demonstrate knowledge of all three branches of the American government, among other changes. There have also been reports of naturalization ceremonies being canceled for applicants from certain countries. Individuals who had completed the full naturalization process, years of waiting, background reviews, interviews, received notification on or near the scheduled date of their ceremony that it would not proceed. Additionally, a travel restriction that took effect on January 1, 2026, added several new countries to an existing list of nations whose citizens face entry restrictions into the United States. An expanded biometric data collection, including facial recognition, now applies to non-citizens, including green card holders, at ports of entry. What the law actually says. Your rights and protections. This section is critically important, and we want to be very precise here. Yes, denaturalization is legally possible, but it is also legally difficult, by design. The courts have consistently recognized citizenship as one of the most fundamental rights a person can hold, and have established a high legal standard for the government to meet before that status can be removed. Here is how the process works. The government cannot simply revoke someone's citizenship through an administrative decision. It must open a formal legal case, either civil or criminal, in federal court, filed by a U.S. attorney. That case is then heard by a federal judge, not an immigration official. The burden of proof lies entirely with the government. The individual being challenged is not required to prove their innocence. The evidentiary standard is substantial. The Supreme Court has addressed this issue multiple times and has been clear that citizenship cannot be taken away lightly. The government must demonstrate not only that a false statement was made during the application process, but that the false statement was material, meaning it actually affected the person's eligibility for citizenship. A minor error, an administrative oversight, or a technical discrepancy that had no bearing on eligibility has consistently been found insufficient by courts to justify denaturalization. Aaron Reichlin-Melnick, an immigration policy expert at the American Immigration Council, has noted publicly that each case must be proved before a federal judge and that the Department of Justice currently faces significant resource constraints. This suggests that a large number of the monthly referrals may not result in actual court cases, and those that do will face meaningful judicial scrutiny. For the vast majority of the estimated 26 million naturalized citizens currently living in the United States who went through the process honestly and accurately, the legal risk of losing citizenship remains low, according to legal analysts. The structural protections, court oversight, high evidentiary requirements, resource limitations, create meaningful barriers against mass denaturalization. The real and documented human impact. Even where the actual legal risk may be limited, the human impact on communities across the country is tangible and documented. Immigration attorneys report a significant increase in inquiries from naturalized citizens who are anxious, including people who became citizens 10, 15, and 20 years ago. Veronica Garcia, a senior staff attorney at the Immigrant Legal Resource Center, has observed that fear within naturalized communities is real, and that this anxiety affects not just individuals but families, children's sense of security, and people's willingness to engage in civic life. Many legal scholars and civil liberties advocates have also raised a deeper structural concern. When naturalized citizens are treated as a category requiring ongoing scrutiny in ways that citizens by birth are not, it creates an implicit distinction that cuts against established constitutional principles. The Supreme Court has stated clearly that naturalized citizens stand on equal legal footing with those born in the country. A system in which citizenship earned through the legal process is treated as perpetually provisional undermines that principle. Legal experts have additionally expressed concern about statements suggesting that denaturalization could be applied based on political expression or viewpoint rather than fraud. The Supreme Court has been unambiguous that citizenship cannot be stripped as a consequence of speech or political participation. Such an application would be unconstitutional. What you can do, right now, if you are a naturalized citizen and you are feeling uncertain or anxious about these developments, here are practical, constructive steps to consider. First, take a measured breath. If you went through the naturalization process honestly, answered all questions accurately, and did not withhold significant information that would have affected your eligibility, you are in a legally strong position. The courts remain an active and meaningful check on government overreach in this area. Second, organize your documents. Locate and secure copies of your naturalization certificate, your passport, and any immigration documents related to your application process. Store these in a safe place where you or a trusted family member can access them. Having organized records is genuinely important if you ever need to respond to any inquiry. Third, if you have a specific concern, consult a professional. If there is something specific you are worried about, a potential error on an old form, a discrepancy you're aware of, do not try to assess it on your own. An experienced immigration attorney can review your particular situation and give you accurate, personalized guidance. Many legal aid organizations offer free or low-cost consultations. Fourth, know the difference between a notice and a loss of status. Receiving a letter or communication from USCIS is not the same thing as losing your citizenship. There is a formal legal process that must be followed, and you have rights at every stage. If you receive any official communication regarding your citizenship status, contact an immigration attorney promptly. Fifth, stay connected to reliable information. Immigration policy is shifting rapidly. Following credible legal organizations and established news sources will help you understand how ongoing developments may or may not apply to your situation. Organizations such as the American Immigration Council, the Immigrant Legal Resource Center, and numerous local legal aid nonprofits are actively monitoring these developments and providing support to individuals who need guidance. The broader picture. Stepping back, what we are seeing in 2026 is a convergence of policy changes that together represent a significant shift in how the federal government is approaching both the path to citizenship and the permanence of citizenship already granted. The expansion of denaturalization referrals to historically unprecedented levels, combined with changes to the naturalization exam, increased scrutiny of marriage-based applications, revisions to travel restrictions, expanded biometric data collection, and reported cancellations of naturalization ceremonies. Taken together, these developments represent a policy environment that is meaningfully different from what existed even a few years ago. At the same time, the legal framework that protects naturalized citizens remains intact. Federal courts continue to operate independently. The Supreme Court's precedents on citizenship rights have not changed, and the evidentiary and procedural requirements for denaturalization remain demanding. The most important thing any naturalized citizen can do in this environment is stay informed, keep their documents organized, seek qualified legal guidance when specific concerns arise, and remember that the rights they earned through the naturalization process are backed by law and by decades of court precedent. Closing thoughts from Zane at Senior Security Updates. Here is the core message we want you to carry from today. You earned your citizenship. You went through a process that required real commitment, time, and patience. America is your home. Know your rights. Understand how the legal process actually works. Connect with qualified legal resources if you have specific concerns. And do not let an environment of uncertainty cause you to feel powerless, because you are not. The courts are still standing. The law still protects you. And staying informed is one of the most meaningful things you can do for yourself and your family right now. If today's video gave you useful information, please share it with someone in your community who needs to hear it. And leave any questions you have in the comments below. The Senior Security Updates team reads everyone. This video is intended for general informational and educational purposes only. It does not constitute legal advice. Immigration law is complex and individual circumstances vary significantly. Please consult a qualified immigration attorney for guidance specific to your situation. Thank you for watching. Stay informed, stay protected, and we will see you in the next one, right here on Senior Security Updates.